So we're going to actually turn to the first page in your curriculum. So again, the book, for those who may came in late, in front of you. And we're going to kind of start actually where most of our starting points seem to be as activists or communities, which is, as Thomas mentioned, the regulatory world. So we'll get to the colonialism aspect, the corporate rights stuff, how the legal system has evolved over the course of the school. But we're going to start kind of at what is the kind of the most logical entry point to a lot of our own activism, is my guess. So if you turn to page 1 after that first blue page, you'll see an article, a little bit dated as far as the year is concerned, but the basic idea of what it talks about is still very much relevant today. So you'll see a couple things in there. We're just going to walk through a little bit of that article and then move on to the next teaching piece. But this is here for a couple of reasons. One, just to kind of reflect again on how that regulatory system works. So Thomas talked about the permit application process, which is one of the entry points where the activism is pointed to. The other is after a permit is issued, there's then holding the permit user to account to whatever the permit says. And so this article is about a particular corporation violating its permit. In this case, it's Smithfield Foods, who Thomas mentioned, who at that point in time in the late 90s was one of the country's largest pork producers. It's now the world's largest pork producer. So it's gotten much bigger. And as far as I believe, it's actually owned by a Chinese company now. But you'll see at the top there that the corporation has violated their permit over a 10-year period 22,520 times. So from what they were able to determine, it's had that many permit violations over the time of which it's held those permits. And again, permits are typically in the environmental realm are about legalizing the amount of pollution that is going to be allowable under a law based on whatever the activity is. So this particular operation is a factory farm. They have a permit, and their permit is basically saying that they can discharge X number of whatever it is based on the permit that they have. But they have violated that permit. They've exceeded it, or they may have discharged something that they're not supposed to. But that's the basic gist of what they're dealing with around their violations. And again, this is a fairly typical thing. If you open up the newspaper or you get online, you'll see these particular cases if it gets to this point about permit violations. And if you look down in that first column, about that third paragraph down after where it talks most of the complaints and the state's lawsuits against Smithfield, if you look down at that column, left-hand column, third paragraph, it talks about what has happened here. It says that there are missing record companies were required to keep. Some were for alleged release of excessive amounts of chlorine, fecal chloroform bacteria, nitrogen, and other pollutants into the Pagan River, Chesapeake Bay tributary. So this is what they're being charged with in the sense of what their violations are about as far as the specifics of what they violated. And the reason that's important in this particular piece is then what happens next. So you have this case of which they violated their permit. Well, what happens? Well, in this case, the state is going after them to say you violated the permit these number of times because of excessive discharges of those various things that we just read in that particular paragraph. From there, it then becomes typically a debate about how much money should be fined to the corporation. And another way to put it is how much has the corporation gained by violating their permit? And so it becomes this negotiation now with the courts, with the state in this case, and the corporation to determine, well, what should we fine you now for what you did in excess of your permits? So if you look in the second column towards the top, the Attorney General in this case, or the Assistant Attorney General, has a very appropriate name. His name is John Butcher for a hog case. But he writes here, or he says here in that first paragraph of the second column, he says, he did not specify how much the state wants Smithfield to be fined, but asked the judge to consider the seriousness of the violations and whether Smithfield had benefited from them. Later on in the article, it talks about the corporation saying, well, we may have violated some of the permits there, but we don't feel that whatever the state is looking for is really equal to what we may have gained financially by violating those permits. So there starts to be this negotiation on a monetary sense. And one of the things why that's important is often the environment itself, those ecosystems themselves, are really not even in the discussion because it becomes this idea of a money transaction. And in fact, in most cases, unless it's specified, that money won't get back to even beginning to do some kind of restoration to the ecosystem. It may go to some other kind of education fund. It obviously goes to attorneys. There's no direct stipulation that the ecosystem, nature itself, is somehow going to regain its former self from being over-polluted by what was already legal pollution, but now in excessive amounts in this particular case. Two other things to pull out of this particular article, which will come back later, as Thomas alluded to, around corporate rights. In this particular case, there was an employee who had done something with the information regarding their wastewater operations. So in that bottom of that second column there, that last paragraph, there's a gentleman named Reddig, where it says here in the article, Reddig ran the company's wastewater operations at 2 packing plants. In August 1994, he was sentenced in January to 30 months in prison after admitting to destroying and falsifying documents. In the case the state is bringing is that this was this culture of deceit going on around the permit violations, and that this particular person was going to be culpable for what he had done. The thing is, his attorney later told him not to speak, in essence not to incriminate himself any more than he had started to in his deposition about that particular operation. So he was exercising his Fifth Amendment rights not to speak, not to incriminate himself. What's interesting about it from a corporate standpoint is in that right hand, or that third column, the one on the right there towards the bottom, not the last paragraph, but the second to last paragraph, the last few lines, it reads here, Smithfield Foods lawyers argued it'd be unfair to use the deposition because they would not get to cross-examine Reddig about his answers. So the deposition that he had started couldn't be submitted to court anymore because that particular person was pleading the Fifth. The corporation now was saying, well, we have Sixth Amendment rights as corporations to confront our accuser. So if you read the Sixth Amendment, that's what the Sixth Amendment says. So when we talk about corporate rights matter, in this case, the corporation was saying evidence that could be damning against them shouldn't be submitted because they couldn't confront their accuser, because guess what? Corporations have the same rights as persons under our system of law. So we see how the corporate rights stuff comes into play, even in this case, which is about the regulatory process, and in this particular instance, the violation of regulations. If you flip to the next page, as a kind of fine point to what Thomas brought up about how the Legal Defense Fund operated, how a lot of communities operate in the sense of dealing with threats to their community, we enter this world that we call the regulatory world, and that our battling is within that confines of however that regulatory world has been shaped. And as Thomas also mentioned, a lot of the regulations of which we may show up to argue at regulatory hearings for the permit issuance, well, initially those laws at the state or federal level are being written by the industry themselves. So they write the legislation, the legislatures adopt that, and then regulators from the state agencies then begin to implement whatever that process is, which often requires this permit application process. So as one can see, we're already working within a system of rules that we're not the ones who are writing the rules, but yet we are forced into that system because that's the world of which we've been told we can do our activism within. And that's where a lot of activism still goes today, especially in the environmental world. So this piece you have here on page 3 called Help, I've Been Colonized and I Can't Get Up, Take a Lawyer and Expert to a Hearing and Call Me in a Decade by Jane Ann Morris, tries to depict what does that look like in general. And some of you may have had this experience in your own activism. In that left-hand column, that last paragraph on the left, can I have someone start reading there and I'll tell you where to stop. It starts with Our Campaigns Follow the Gambling Addiction. Does anyone want to exercise their voice late on a Friday night? Anthony or Dina?
Our campaigns follow the gambling addiction model. The last bet didn't pay off, but the next one might if we had just had a new improved tripod, 3 more experts, more labor and church support, 10 more elected officials on our side, 100 more people at the demo, or 1,000 more letters in the mail. Who are we kidding? We're just doing the same old thing over and over again and fooling ourselves that it might work next time. We are stuck in a feedback loop where our failures are interpreted as signs that we should repeat our failed tactics but try harder. This is what is to be colonized. The telltale signs, not that we're failing, but that we're fooling ourselves and don't see it as a feedback loop.
Stop there. So we're going to flip to page 4 and pick it up about 4 paragraphs down where it starts, Corporate Strategy Leverages Their Power. Dina, do you want to read those 2 paragraphs?
Yeah, where is it?
So
Left side on page 4,
Okay.
corporate strategy.
Corporate strategy leverages leverages their power. Their efforts reinforce and magnify each other. Our strategy splits our resources and dissipates our power. Corporate strategy aims to increase the power that corporations have over people. That means that when a single corporation gets a victory, it helps all other corporations too. They are all stronger, they are all have more power, and the people have less.
All right, stop there. Switching over to that right-hand column, third paragraph now where it starts, another sure sign of being colonized. Does someone want to?
Another sure sign of being colonized is when you censor yourselves and don't even wait for others to do it. Some of our self-imposed limitations are right off of a corporate wish list. We have a strange, but it's the law syndrome. Why can't we bring up important issues at EPA hearings? It's regulatory, administrative law. Why can't we get our views accurately presented on TV? It's corporate, private property law, and FCC regulations. Why can't we imprison corporate executives for what their corporations do? It's liability law. So what do? We toe the line at the EPA hearing. We dress up as animals to get a moment on TV. We let lying corporate executives lie. That is, we work around the defining laws that are the groundwork for a rigged system. We're looking for favors, lucky breaks. We don't even dream of control, yet we call this a democracy. This is being colonized.
All right, stop there. I'm going to skip over to page 5. Do we have another volunteer reader? So you're going to right-hand column. You're going to go down to that third full paragraph where it starts, a big part of the script written for us involves.
A big part of the script written for us involves regulatory law, including environmental and administrative law. It assumes that corporations have the right of constitutional persons. It outlines procedures for what we the people can do, not much, what government can do, a little more, and what corporations can do, a lot. At regulatory agencies, corporate persons, that is, corporations, have constitutional rights to due process and equal protections that human persons, effective citizens, do not have. For non-corporate human citizens, there is a democracy theme park where we can pull levers on voting machines and talk into microphones at hearings. But don't worry, they're not connected to anything and nobody's listening except us. What regulatory laws regulates is citizens' input, not corporate behavior.
All right, stop there.
Okay.
So when Thomas mentioned about environmental laws regulating environmentalists, that came from the woman who wrote this piece, Jane Ann Morse. So that's kind of her other take on when we make ourselves predictable, when we play by other people's rules, how easy it is to basically control the situation and where we sit in relation to power. And another important thing that she brings up is this idea of defining law. So who's actually writing that defining law, then who's really operating under that kind of regulatory law? And her point is that so much of the defining law is not really being written by the people, it's being written by the small, powerful few. In this case, the corporations today are the ones writing most of the laws that regulate themselves or dictate their own behavior. Yet we still come into believing that we can stop corporations at their own game when it's their game to begin with. And I think that's her whole point of pointing out how our activism perhaps needs to think differently, and what we aim for needs to be something different than what it's been so far. So on page 6, she goes further, and I'll read this part. So that left-hand column, second paragraph down, where it starts, corporations are not natural entities. Corporations are not natural entities like Karner blue butterflies or white pines. Corporations are artificial creations that are set up by state corporation codes. These state laws plus a bunch of court cases form the basis of the notion that corporations have powers and quote-unquote rights. The law is defining law. The law is the script that corporate lawyers write for corporations. This law is the law that we don't even read. It's just right there in law books in black and white, just like the regs that we spend so much time on. But this defining law is invisible to us because we've been colonized and have accepted it as a given. We leave this defining law in corporation codes, bankruptcy law, insurance law, etc. to corporation lawyers who rewrite it every few years without so much as a whimper from citizen activists. Then we wonder why the parts per million regulations aren't enforced. And to finish off this piece, next column over, first full paragraph down that reads, if the civil rights movement, who would like to read that paragraph?
If the civil rights movement had been afraid to touch the deep defining law of the land, we'd still be laboring under separate but equal. For as long as we stick to regulatory law and leave defining law to corporate lawyers, we'll have corporate government.
So that's Jane Ann Morris, and as Thomas mentioned, you know, the journey for Democracy Schools to get more deeply into all of that. So this is just about kind of setting the scene. So hopefully your questions will come up and be answered as we move through. But also feel free, if something comes to you around a comment or a question, just jump on in. We're just going to keep moving along. So your next few sections, you know, we talk a lot about law and government in Democracy School, but really this is all about cultural affirmation in a lot of ways, that law has been used to rationalize behavior, rationalize actions, which is also very much connected to how culture's moved. And as part of how you've defined and shaped culture, of course, there's language, and there's the power of language. And so these next few sections are really talking about how language has shaped even things around regulatory laws or certain practices because of how you word it, and then begin talking about it. And so Brad's going to go through these next few sections, starting off with the piece on page 9 called Propaganda.
Just one quick real-life Spokane story back to the Morris piece where she says we get to pull levers on voting machines and participate in Democracy Theme Park and talk into microphones at hearings, but don't worry, they're not even connected and nobody's listening anyway. In 2006, the Walmart Corporation was beginning a siting process at 44th and Regal on the South Hill. And there was a mass meeting in the Ferris High School cafeteria, and over 1,000 people, standing room only, showed up, the vast majority of whom were there to say no to Walmart. It kind of, you know, it's you know, local example of what Tom was talking about. And the stated objective of the folks running the meeting, who were, I think there was a lawyer or two there, traffic engineers for Walmart, was to do traffic scoping, and you know, how many trips a day and traffic lights and all of that. And it was clear from the beginning that the majority of people in the room wanted to talk about a multiplicity of issues: worker rights, the destruction of small business, the destruction of neighborhoods, all the things that go with big box stores. And those folks running the meeting said, we know that many of you are here for a number of reasons. You are welcome to say what you like. The only comments we will write are those that have to do with traffic. And so they actually lived out, they demonstrated what Morris is talking about. We're only going to pay attention to the folks who are going to talk about what we want to listen to. The rest of you can say whatever you want. It made the newspaper, but the only comments that were recorded were anything that had to do with traffic and trips and
Who said this?
the engineers running the meeting, those people working for Walmart Corporation. So as Kai said, this is about language, and I want you to, because I like it, when Tom said, you know, we didn't have leverage to fight the permits. Think about a giant machine with a bunch of levers, because the structure of law is one that's been carefully crafted over a couple of centuries. And those who crafted it know where the leverage points and the levers are, and those of us who come up against it see this giant behemoth and don't know where the levers are. And one of those tools of leverage to mask the real intent is the use of public relations. And so on page 9 starts this excerpt from a book called Propaganda by Edward Bernays, who is generally accepted as the father of modern public relations. If you put your thumb in page 10 and then skip over to page 13, you'll see, and this goes against all scholarly things that you shouldn't tell students to do, but we took a Wikipedia entry on Edward Bernays, a brief biography. But his book is titled Propaganda. It's not titled Public Relations, which is kind of this naked truth that then got massaged into public relations. We'll look at Bernays' career in a minute. And this reminds me of what Earl said in the go-around, which is the Churchill quote about the best argument against democracy is a 5-minute conversation with the average voter. So why is it that people are so easily swayed by currents? And Bernays' words themselves on the top of page 10, I think describe the moment we're in, but remember, this is actually almost 90 years old. Like Tom said, it didn't start with Trump. So Bernays says in chapter 1, the title of which is Organizing Chaos, the conscious and intelligent manipulation of the organized habits and opinions of the masses is an important element in democratic society. Those who manipulate this unseen mechanism of society constitute an invisible government, which is the true ruling power of our country. Now, I have students all the time who want to say that there's a shadow government and the Illuminati makes all these decisions. And that's just kind of, that silly talk. But I think what Bernays is actually nakedly explaining is those who have the tools run the machine and consciously mask it. He continues, we are governed, our minds are molded, our tastes formed, our ideas suggested, largely by men we have never heard of. This is a logical result of the way in which our democratic society is organized. Vast numbers of human beings must cooperate in this manner if they are to live together as a smoothly functioning society. I don't suspect, given what we heard in the go-around, that any of you are surprised by this. But having the words of the man who is credited with all the pioneering achievements in marketing and public relations, I think puts a face to it. Now, if you flip to the Wikipedia biography, right in the middle of the first page on 13, it talks about Bernays' one of his favorite uses was third-party authorities to plead his clients' causes. The technique of saying, and the Trident sugarless gum campaign, for those who are old enough to remember, 4 out of 5 dentists surveyed recommend sugarless gum. There was no survey, you know that, but this is a Bernays technique, 40 to 50 years later. He said if you can influence the leaders, either with or without their conscious cooperation, you automatically influence the group which they sway. On the bottom of the page and over onto page 14 are some of the campaigns he was credited with pioneering. In the 20s, when he was working for the American Tobacco Company, he sent a bunch of young women models to stand on the corners in a parade in New York City, lighting torches of freedom, which were cigarettes. And so their willingness to smoke in public was a gesture of freedom. If you flip over to page 14, he was also the nephew of Sigmund Freud, used some of Freud's techniques to pioneer the concept that eggs and bacon were the true all-American breakfast. He was behind the Dixie Cup Company's campaign to convince people that the only way to drink out of a sanitary cup was disposable paper cups. He was credited with the term banana republic and helping to overthrow the legitimately elected government of Arbenz in Guatemala in 1954 at the behest of the United Fruit Company, today's Chiquita. He helped the Aluminum Company of America, Alcoa, convince the American public that fluoridation was safe and beneficial to human health. So you can kind of check off the 20th century and all the things that were done in the name of expertise, and this is the way it has to be to Edward Bernays. As an example of the way that language and crafting opinion is a tool of this giant machine. Now for the next thing, before you read anything else, I want you to close your eyes. I'm going to give you a guided meditation. And I want you to imagine you're watching a TV commercial, and the commercial is for an organization called the Water Environment Federation. Keep your eyes closed. Tell me what you see.
I'm good. Sounds good.
A waterfall.
An island.
An island.
Moving water.
Give me some colors. Give me.
Green.
Blue, green, and brown. Yeah.
Is the water clear, clean, pristine?
Yes. Mhm.
All right, now you can open your eyes. The Water Environment Federation is actually the name of the trade association that represents the sewage industry. And so this article takes you through the rebranding for public relations purposes of this group that began in 1928, same year Bernays' book was published, as the Federation of Sewage Works Associations. That tells you what it is, fairly clearly and honestly. In 1950, they recognized the growing significance of industrial waste in sludge, and then changed the name to the Federation of Sewage and Industrial Waste Associations. 10 years later, changed it to the Water Pollution Control Federation. That evolved into the Water Environment Federation. So you can see the morphing of language to form public opinion, to make people see what is not actually there. In 1977, the manager of the Seattle City Sludge Program, a guy named Peter Mochno, this is right in the middle of page 15, he was heading a name change task force. Because in Washington State, when stuff goes down the toilet or the drain, the water is separated from the solids. The water is sent to treatment plants in municipalities with sewers. I think something like 60% of the solid, once they're separated out, is then applied in Washington State to farmland as fertilizer. And the Water Environment Federation didn't think that calling it sludge would go over very well, so they created a contest in which they asked for submissions to change the name. So I want you to look in that middle paragraph on page 15 and tell me the one that you love the most.
Black gold.
Black gold.
Humanure.
Humanure.
Organic residuals. Organic.
Organic residuals. What does that sound like?
Something organic,
Something
leftover
natural
from
and
eating, an orange and what's left over.
right.
Yeah.
And what we're talking about is all the stuff that goes down in municipal waste streams. What I love is SCADU, the end product. The result in 1991 was the name change task force settled on biosolids, and then defined it as the, quote, nutrient-rich organic byproduct of the nation's wastewater treatment process. One of the submissions there was ROSE, recycling of solids environmentally, which calls to mind the Shakespeare quote, a rose by any other name. Look at that second to last paragraph on page 15. The new name drew sarcastic comment from the Doublespeak Quarterly Review. The Professor William Lutz says, does it still stink? It's obviously coming from an engineering mentality. It does have one great virtue, though. This is a reference to biosolids. You think of biosolids and your mind goes blank. And then Mochno, the guy in charge of the name change task force, says it wasn't designed to cover something up or hide something from the public. We're trying to come up with a term that can communicate to the public the value of this product that we spend an awful lot of money on, turning into a product that we use in a beneficial way. Flip over to page 16. Those last two paragraphs. This is at the group's 64th annual conference. The president of the Water Environment Federation says, we don't control pollution anymore, we eliminate it. To the outside world, our people came to be seen as pollution people. In today's world, the word control just isn't good enough. And then there's a reference there in 1992, the Water Environment Federation, which is the trade association for the shit recyclers, got a $300,000 grant from the EPA to educate the public about the beneficial uses of sludge. So think about how, in other examples, language and public relations are used to shift focus away. I mean, it's almost like, the art of illusion and prestidigitation that magicians use. Look here so you don't look over here. We're gonna skip through the next couple. There's a number of things here about the concentration of animal agriculture in Pennsylvania. Those will be there for you to look at your leisure. They're there to reinforce how the way that what became concentrated industrial vertically integrated farming, as Tom was describing, came to be known as modern farming. One more example of the way in which there's a reference on page 23 to the way in which the image of farming is changed. And notice at the bottom of page 23, it's from the Penn Ag Industries webpage from 2008. This is not at all limited, as we know, to the fights of environmental activism, the way in which environmental laws, as Morris says, are designed to regulate us. It also works in organized labor under the kinds of protections we expect under the National Labor Relations Act to have protected workers. But if Morris is right that environmental regulations regulate environmentalists and labor regulations regulate workers. And so the next pieces that we'll look at start on page 29, and Kai's going to go through those two.
Yeah, we're not going to spend a whole lot of time here, but to Brad's point, you know, we talk a lot about the environmental regulations, because that's where the Democracy School comes out of. That's where a lot of the fights still are happening on the community level. But people are also regulated, and specifically workers, under a similar type of regulatory type scheme. So workers are really articles of commerce in a lot of ways under the National Relations Labor Board operations of how they function. Just like the environment is regulated in a lot of ways, so are workers, and that there is a gross disparity between the type of rights recognized for workers in the workplace than there is for the employers themselves. And so this piece on page 30 or 29, and then continuing on page 30 and 31, is really just to highlight that labor is also highly regulated, since we're talking about regulations here. And just to point out a couple things about what that actually looks like on the ground. If you look on page 30 towards the top there, under the heading Free Speech, where the author here, who's a professor at the University of Oregon, he writes, under federal labor law, management is permitted not only unlimited reign to voice anti-union arguments to employees, but also nearly unlimited reign to stifle employees' own political speech. Indeed, one federal commission found that there were upwards of 10,000 cases per year of workers being punished for engaging in pro-union speech. Even though we recognize free speech rights out in the world and our communities, the truth is, in at least the private sector, you don't have First Amendment rights in the same way you do outside of work. Yet corporations have First Amendment rights as corporations. The point here is that a lot of even the constitutional rights that we think we carry with us everywhere, there are environments like the workplace where that's not the case. Yet in this case, employers have, in ways, unlimited free speech rights where the workers themselves don't, on the way that how the system operates today. And then just skipping over to page 31, just to give you a sense if there are workers who do want to unionize, what they're up against in the sense of these unionization campaigns. In that big paragraph there, third line down, where it references the board. This is the National Labor Relations Board. That's the regulatory body. In some ways, you can kind of think about it as the EPA for workers. This is the body that does the overseeing of worker rights in this country. It says here, the board has declared that it will police campaign propaganda only to the extent that the printed materials must be identified as something coming from one side or the other. Beyond this, the board does not probe into the truth or falsity of the party's campaign statements, and will not set aside election on the basis of misleading campaign statements. So think about in campaigns today, if you're a public campaign for office or you're around for or against a measure, we have laws in place that says you need to be following certain rules and regulations, and you can be held, liable for false claims. In the workplace, it's not the case, meaning that so long as it's just identified where campaign materials are coming from, that's all that the board is really looking at. And if you're already in a position where there's unequal power between who can speak and who can't, you can see how difficult it is if you're wanting to engage in organized labor, how hard it is in the corporate workplace today to do that. It's not even in the corporate workplace. I actually gave a talk a few years ago to the Department of Ecology out in Olympia, and it was the union that invited me out there. But the union wasn't able to use the state email system to notify people of the talk. They had to find other means to let people know that the talk was happening, because even in public work, even as public employees, there are stipulations and restrictions on free speech. So it's not as widespread as we would think it would be in the workplace. And so that's the reason why we put it in here, is just to remind us that even though we talk a lot about the environment, and a lot of examples about the environment, that workers are also regulated in a lot of the same ways as natural resources are.
We used to use the emails anyway. We took turns. I was a union officer there. We took turns deciding who was going to violate the ban this time. So every time we had a speaker, somebody else would violate it and get reprimanded. So we spread the reprimands around.
So the next piece is on page 33. It's called Fear at Work. And this is here solely to talk about, where does this whole idea of regulations come from, or the regulatory body or regulatory agencies? Because so much, again, of activism, again, runs up against this regulatory system, because that's where we're driven to, that's where we're funneled towards, whether it's the legal system or the state agencies or the activist groups. It's all about, we got to appeal the permit, appeal the permit, appeal the permit. And so where does this thing even come from? And the origins around at least a lot of the federal environmental regulatory agencies come from the 1800s, and they come from the railroad industry. And you'll hear a lot about the railroad industry in Democracy School, because a lot of our law and governance has been shaped by the railroad industry, from Supreme Court justices to corporate constitutional rights to the regulatory system we have today. You can thank the railroad companies for that.
Is that where the term railroading comes from? Being railroaded.
So that first regulatory agency that we had, at least on the federal level, was called the Interstate Commerce Commission. So that was the name of the organization. It doesn't exist anymore. It's their purview, or their area of responsibility is now under something called the Surface Transportation Board. But they became the model for a lot of the regulatory agencies that formulated after them. And so what did that really mean to the industry? There's a quote in here that we put in to show you what the industry thought about regulations, because often we hear in the news, corporations want less regulations, we want to be less regulated, there's too many regulations. But you can also get a feel for what corporations think about regulations in the sense of what good it can do for them, because in a lot of ways, from a legal standpoint, it creates a liability buffer for them, because they're only liable for whatever the regulations say, for instance. Plus, it's also a way to keep a distance between people and communities and the activity that's happening, because now it's quote-unquote regulated. So there's this air, again, that it's going to be safe. So talking about language, in Pennsylvania, the regulatory agency is the Department of Environmental Protection. So people believe that the regulations are about protecting communities and the environment, where they're often about making sure that the corporation's activities, of course, continue to move forward with the least amount of obstructions, but give the sense that we're doing everything we can to protect the environment. So it has...
Isn't it the DEQ in Oregon?
I think it's the DEQ in Oregon. So page 34, there's this quote from a guy named Richard Olney, who was the Attorney General at the time of the 1800s. So it says here, from the industry's perspective, the good thing about the ICC, which is the Interstate Commerce Commission, was that it would stabilize prices and profits without challenging corporate power. As U.S. Attorney Richard Olney assured the president of the Burlington Railroad in 1893, he said, "The commission is or can be made of great help to the railroads. It satisfies the popular clamor for government supervision of the railroads at the same time that the supervision is almost entirely nominal. Further, the older such a commission gets to be, the more inclined it will be to take the business and railroad side of things. It thus becomes a sort of barrier between the railroad corporations and the people, and a sort of protection against hasty and crude legislation hostile to railroad interests." So you can hear from very high-level officials themselves that their views of what that regulatory body was doing, and this person's view, and I think a lot of others, is that it creates this buffer, this barrier between the industry and the people. And I think back to Jane Ann Morris, the question is who's being regulated? Is it the industry or is it us? And I think that's what this brings up. So as kind of one more piece around really the regulatory world, and then we'll move on. If you flip back in your curriculum to page 25, you'll see a diagram of a triangle. And we want to use this as sort of a visual about how this kind of regulatory interaction looks. So when we enter the regulatory world, we enter these permit appeals, what does that really look like from a visual standpoint? And what is actually going on beyond just showing up and testifying at the hearing? What does the actual process look like, as Thomas was talking about, being successful the first 1, 2, 3, 4, 5 rounds around these permit applications, but eventually losing because all he was doing really was solidifying the validity of the permit application to the point where the judge had to say, yes, we're going to now administratively issue the permit. What does that really look like from a community standpoint? That's the purpose of what we call this regulatory triangle that Brad's going to walk us through.
So for this illustration, I want to start with the issue of factory farms, as Tom described in the early days of the evolution of the Community Environmental Legal Defense Fund, but it applies to every issue. So Kai's work in communities in Oregon that are fighting GMOs. There are communities in Ohio and Colorado fighting fracking. So it's not the issue so much as the nature of the system. If we start with factory farms that were coming into South Central Pennsylvania, you had groups of people saying, we don't want these, as Tom described. And they would create a list because there's a multiplicity of issues of why 10,000, 15,000 head hog factory farm is a bad idea for a community. So you've got a decrease in property value, you've got public health issues, you've got air and water quality. What else can you think of all the issues that a giant concentrated animal farming operation would create in the community?
It stinks.
Quality of
Yeah,
life.
odor.
Oh.
What else?
Noise.
You've got transportation issues because trucks are going in and out all times of the day and night. What else?
Worker safety issues.
Yeah.
For the hogs, is it antibiotics?
What was it?
Yeah, the welfare of the animals, the antibiotics, the hormones, which link back to air and water quality, right? So what you have is this, go ahead.
Just like waste landfills.
Yeah, what do you do with the waste? This challenged my whole notion of the word lagoon, because I grew up watching Gilligan's Island. The disposal ponds where you deal with the manure are called manure lagoons. So just let that ruminate for a minute. But this is a huge, complex set of problems. The community identifies, and they want to stop this because of all of these reasons. Take out factory farms, put in fracking, you have a similar list. Take out fracking, put in GMOs, put in pesticide spraying, put in any number of issues. You have this complex problem statement. And so as Tom described, when you go to the state agency, that's the first place you call. Their first response is to reframe the problem. Well, we can't deal with all of these things, but we can move it to something which is manageable and controllable, and they start moving down the side of the triangle. This is called the single regulatory point. We don't want to talk about noise. We don't want to talk about transportation and how many trips and the effect on the roads. We don't want to talk about public health worker safety, the antibiotics in the animals and therefore in the waste. But we will talk about the parts per million of poop. So that's a regulatory point we can talk about. If it's over 10, then it's not safe. If it's over 100, it's not safe. The next thing that happens is the corporate lawyers do the same thing. Take this massive complex problem statement and say, well, we can't deal with all of that, it's too complex. What we can let you argue is whether the parts per million exceeds safe levels. Besides the state agency and the corporate lawyers, you've also got elected officials, who in most municipalities are going to say the same thing. And so it seems, as we understand the system so far, it seems like this makes sense, right? It would be in their interest in enforcing regulations to not deal with all of this. Let's make it about something we can easily control. What happens as a result, and this came out of the work of the Legal Defense Fund in that first 7 years, is a realization that not only are they trying to move us down the triangle to this single point that they have control over, but we do the same thing. That we do what Morris describes, that we let the regulations regulate us, and we participate in this process and end up going to a hearing to talk about traffic when there's a Walmart sighting. Or we talk about, in the case of fracking, it has to do with well casings and how thick the concrete is and what's safe. Not about all of this, which are the community concerns, but what will they let us talk about? And the reason the triangle works as a visual, this is the first step in our mini geometry lesson tonight, because the next one is also a geometric shape. But the reason this works so well is it kind of simulates what happens in a factory farm. Because when the animals get to the bottom of the chute, what happens? They get a bolt in the head, right? And that's what happens to us. Because the problem was complex. And we participate in the process in this regulatory system to let other people frame the problem and take all this away. The idea of the Legal Defense Fund work and the idea that birthed Democracy School is how do we take this triangle and flip it upside down and move people away from this point, which is now at the top, to make the laws which address this stuff, which is now at the bottom. One of the reasons that we can't do that in communities is the next of our geometry lessons, which is a square. It's very elementary geometry. This is a box. We'll come back to this because it's a useful way to talk about some of the evolving work around the country tomorrow. But the recreation in the curriculum book, I think, does a really good job of visualizing why we all start here and we end up traveling down here and then are surprised when the bolt goes in our heads.
And they can easily figure out an answer to that one little issue.
Absolutely.
The parts per million.
Which is why that's the only thing we can talk about. Right.
And keep in mind in this example, as Tom mentioned, and as Brad laid out, in Pennsylvania, this all came out of that Nutrient Management Act, as they call it. So how are the factory farms going to handle the manure? I mean, that became the focus of the regulations around factory farms. So that was all the state agencies could look at in the sense of factory farming. It had all to do with the manure management as the industry had defined it, as the state legislature had adopted it, and as the state agency has to administer it. So the complex problem became simplified by the lawmaking piece of how the industry was able to then shape the law, which then shapes things like the permitting process, which then eventually also shapes our activism because we fight within the system of the rules that they have set up. And this is
first set up that it presupposes that it's going to be there.
yes,
Absolutely.
which is also in the word permit. If you think about it, the word permit means to, or permit means to permit, right? So even that by itself predisposes that the outcome is going to be what the outcome is going to be. And I think that's part of the lesson that this organization has learned. It's the lesson that a lot of communities have learned. But it's still very much where a lot of the activism works today, because, you know, some other circumstances beyond the system itself may have stopped X, Y, and Z. Usually it's economic related, perhaps political influence, but the basic operation of how the legal system functions is this. And this is really what most communities run into when they deal with pipelines or frack wells or factory farms or whatever it is. It's this kind of system. So part of the school is to show how does that system look, but also question whether or not do we want to enter this system of which it's already been predisposed, you know? And I think that's the, again, the geometry of it is there for a purpose. The next piece isn't in your book, but it's meant to be kind of a placeholder to think about the other realities of where we sit in our communities, whether we're looking for greater democracy or whatever it may be. What are we allowed to do? And so we formulate this thing called the box of allowable activism. You can call it the box of allowable remedies, the box of allowable democracy, however you want to phrase it. We have this operational system today under the way that the law works that keeps us basically in a box. Okay, each side is really a different legal doctrine out there that shapes what we can do in our communities. And it's very much in full effect, even if it's not visible to us. And so what we've been talking about a lot since we started the school tonight really comes out of this thing called preemption, okay? We have both state and federal preemption. And the basic order is the federal trumps the state, and the state trumps the local. And excuse my use of the word Trump. I used to be able to say that without having to make that excuse. But preemption, we have this system, okay, of preemption, which, as Thomas mentioned, you have no legal authority to say no to the factory farm because you are preempted. The state has sole authority over that particular legal use. And that's how our system works today. The interesting thing around all these legal doctrines, for the most part, they're all judicially created. Okay, what I mean by that, the courts basically made determinations that things like preemption would exist. This is a creation of the courts. Okay, this idea that states can preempt the local from the preemption standpoint. But that's mostly what communities run into. And it's also what the corporations understand that they need to control. If you can control the state legislature, in essence, you control the state laws, you can control everything down at the community level. So the GMO example was brought up in Oregon a couple of years ago. They passed a new piece of state legislation that said no community can have anything to do with GMO seed. That was the authority of the state. There's now a bill in the legislature in Oregon that's talking about no community can have any regulatory or banning control of any fossil fuel transportation in their community. That's the sole responsibility of the state. So it's all about preempting the local through the use of preemption. Or on social justice issues, the whole people who've been following the bathroom law in North Carolina, well, that's the state preempting the local from passing any sort of a civil rights protection. Or in Alabama and a lot of other states, they have passed laws preempting localities from moving higher minimum wages than whatever the state sets. That all operates under this legal doctrine called preemption. In those cases, the state's using preemptive lawmaking to override local decision making. So preemption is a lot of what we've been talking about in this first part. Another thing that we'll get to really only at the end of tomorrow, something called Dillon's Rule. And Dillon's Rule is, again, a legal doctrine. It's named after a Supreme Court justice from the state of Iowa in the 1800s, again, a friend of the railroad industry. And though we'll dig into this more tomorrow, the basic premise is that the state is considered the parent and the local is considered the child. And the local government can only do what the state says it can do, all right? So it has to get permission from the state. The reality is municipal corporations, which are our government, are created by the state. And that power then to the locality comes from the state itself. That power can also be unilaterally taken away from the locality if the state so chooses. That the state or the local is not independent of the state, it's merely an extension of the state and has whatever powers the state says it can have. So a recent contemporary example was in the whole water debacle in Flint, Michigan. Well, that was the state coming in to override local power over the water system, where they appointed a state administrator for their water system, where they wiped out the whole local government. Well, they can do that under the power of how Dillon's rule operates, because the reality is local governments exist because the state spawns them and have the powers which the state says they can or can't have. And the reasons why preemption and Dillon's rule come to play in communities, the communities we've been working with, and really anywhere else where you confront corporate projects, for instance, corporations can use things like Dillon's rule against you. So if you say no to that big box store, they can say, well, you don't have the authority under Dillon's rule to make that kind of decision because the state has not given you that authority. So not only can you use preemption against you, they can use things like Dillon's rule against you. Another side of the box that we'll get into tomorrow, coming out of the body of the Constitution, are things like Commerce Clause, the U.S. Commerce Clause. Okay, we have this thing under the powers of Congress. One of them is the power to oversee everything dealing with commerce. And such that the Commerce Clause is another thing corporations will use against communities who try to dictate things within their own community. And again, it could be around labor rights, it could be around environmental issues, it could be around land use. But if you do something of which restricts that legal use, for instance, at the community level, you pass that big box, no big box store law, well, not only are you going to violate preemption and Dillon's rule, you're also going to violate the Commerce Clause of the U.S. Constitution. Well, why would that be? Well, you're interfering now with commerce, and a big box store would be deemed commerce. And you at the local level don't have that legal authority under the way that our system of government operates today to interfere with commerce. And so your local law would be stricken using the Commerce Clause side of this box if the corporation so choose to do so. The other side of the box is really the one that has gotten more press of late, are corporate rights. These are really the ones, tied to the Bill of Rights of the federal Constitution. So the First Amendment rights coming out of the Citizens United case, those are real legal powers of which corporations have. Again, if you were to adopt, for instance, a no big box store law, well, one of the rights, corporate rights you'd be violating would be the corporation's 14th Amendment rights to equal protection under the law. Because now you're differentiating between, let's say, local business and the big box stores, and so you have an unequal situation in your community, and so the corporation could sue your community for violating their 14th Amendment rights. So the purpose of the box is to show that when we are looking to do really serious stuff in our communities of the bigger issues, how we're actually boxed in as it sits today under the way that the legal doctrines, these major legal doctrines, function. And also keep in mind that corporations don't have to use all four sides of the box if they so choose. They could use one of those and most likely win in a legal sense because of the power of which all these things sit. And so, again, the lesson from the visual here is to show, well, if we want to do something well and we want to be good boys and girls about it, we have to stay inside the box. And when it comes down to really doing the real stuff, what are we actually capable of doing if this legal system operates the way it does? Meaning, is it going to let us be more sustainable around our food production? Or is it going to let us be more progressive in our sense of civil rights protections or worker rights under the way that the system functions? And so we run into these walls, these containment systems under the way that the system functions today. And again, we'll dig deeper into why that came to be, especially around things like Dillon's rules and the Commerce Clause and corporate constitutional rights. So we put this up there just to give us a sense of, again, how communities are operating today, not just within that regulatory triangle world, but the other aspects. So that regulatory triangle stuff is really linked to this preemption stuff. So it's really also bound by the fact that regulatory law also can't violate these other legal doctrines out there. So when Jane Ann Morris talks about, and these regulatory hearings, that regulatory agencies have to be mindful of corporations' equal protection and due process rights, well, this is exactly what she means. So even if a regulatory agency wanted to do something, let's see, to be more stringent in the way that a corporation operates, It has to be conscious of the fact that it could be violating things like corporations' constitutional rights, or even things like Commerce Clause rights. So it even limits the ability to do the good stuff by the fact that these other legal doctrines exist beyond just the preemptive power that may have been passed at the state or the federal level. Maurice?
Well, just because something falls outside of allowable activism wouldn't necessarily make it illegal, would it?
No, it all depends on what you're looking to do. So the question is if it's about, I mean, you have to look at the particular issue, but if you begin to look at the more serious issues of what we want to address in our communities, in most cases, it's going to unfortunately sit inside this box on the way.
So you're talking like hearings and court cases within the box?
Well, I'm talking about if your issue was, I'm dealing with a community in Oregon right now that wants to stop aerial spraying of pesticides by the logging industry. Well, it's going to run into preemption through the forest acts that Oregon has around state preemption of state authority over pesticide use. It's going to run into things like Dillon's rule. It's going to run into corporate rights. So the question is, when we're looking at organizing on a particular issue, where is that going to sit in relation to what we're capable of doing? And even if it doesn't sit within the box, where do we really get to go based on the fact that the system operates the way it does? Meaning, are we actually going after what we want or what we can get with one that the system allows, and that becomes part of the organizing decision too.
There's a really good example, I think, right here in Spokane, and we have talked about it here, is Native American treaty rights and the Spokane River. The reason that we're having all of these somersaults about nutrient management out of the sewage treatment plant and what level we're supposed to reach is because the Spokane tribe has, in fact, treaty rights to water quality in the lake that forms the terminus of the river towards the Columbia River, the Long Lake. It's driving all of this stormwater bypass investment and so forth. I think that really fascinating thing to me is the way they turned this whole thing on its head is they started out by talking, let's talk about mitigation. What's the perfect situation look like? And then they started bringing in these other issues about, for instance, like that long list that you had on the previous page, those became impediments to the perfect situation that we're all cooperating to build, supposedly. So the tribe said, well, we could sue you in federal court for treaty rights, or we could sit down and talk about what it would take to fix the problem. But they're pretty powerful negotiators in what it takes to fix the problem because they've got that treaty rights. And then they start trapping the polluters, I guess, I call it trapping them in their unwillingness or inability to mitigate to that perfect solution. You know, that we all agree, well, we'd be fine with this if we just had better water. How do we get to better water? And then they start having problems figuring out how to do that in the way that they wanted to. So that the corporate model of just shoving this down to one issue kind of gets turned on its head. It starts out as one vision, and then you start seeing all these problems trying to get to that vision as you start supposedly working together.
Yeah, I think there's some parallels starting to come out of this work, which is who has decision-making power and on what grounds. And I think that's what things are leading to. And I think there are some areas of which the tribes, obviously as sovereign nations, have been able to do things. I mean, obviously they're still under the control of the federal government. They still have to, in most cases, sort of prove economic impacts more so than really truly what we want to be doing on a sustainability standpoint. But
my argument is that they've used the PR piece very effectively. They've said, we don't want to stop you, we just want it to be perfect. And here's how we can make it perfect. Let's talk about perfect.
So we're going to get through one more piece and then take a break before we power through the last bit before we get to around 9 o'clock. And the next section is going to go to a piece.
Two quick visuals. One is, if you ever played the carnival game Whack-A-Mole, that's kind of the way the box works. We're the moles and we get whacked by hammers we can't see. The other one is, this is a visual spatial challenge, but that box is actually three-dimensional, and so there's multiple sides. Think of it as a cube, and it's not just the four sides, but there's the walls close in on us in communities constantly from all directions.
Yeah, and I think just one more point on that. I mean, what we've seen happen as communities have mobilized to deal with their realities of what power they don't have under the system. Often what happens is, new preemptive law comes into play to override that ability to want to have more self-governing power, like in North Carolina or like in Alabama or wherever. In a lot of the fracking, states that we work in, immediately there becomes new state preemptive law to basically shut down the ability of localities to have any decision-making power. And so, it is not static. In essence, there's dynamic, it's ever-changing, and the closer you get to touching where the real true power lies, the more you'll see that power snap back to try to suppress the ability of communities to be decision makers.
But since corporations are people, they're subject to appeal to empathy, right?
What was that? What did you say?
She was saying that corporations can be appealed to on empathetic grounds because they're people.
So if you flip your curriculum to page 37, this piece kind of jumps very much out of the regulatory world and starts to go sort of back in time and really begin to sort of address this question about, constitutions. Where do constitutions come from? What do constitutions really mean? Sort of the bedrock kind of stuff, really pulling it apart and analyzing it and giving us a sense to maybe look at things like constitutions perhaps differently than we have before, even just going through this particular piece. And Brad's going to take us through that next.
So if you weren't pissed or depressed enough yet, now we take the deep dive into history all the way back to 1066 and the Norman conquest of England. And to refer back to both Dina and Earl's comments about missing things in civics class, I remember being in junior high in Spokane Public Schools and learning about the Magna Carta. I already grew up with this conditioned response that when you mention the Constitution, an angel choir happens. Right? That started with the Magna Carta, and that's what I learned in middle school in Glover Junior High in 1973 in Spokane. And I was taught that, and I'm guessing many of us were as well, that the Magna Carta was the model structure for the Constitution, and that was the spirit of the Enlightenment, which informed the Magna Carta, which all of the wise founding fathers used in writing the Constitution. I want to start. This is an article called "The Spirit of American Government" by J. Allen Smith, a study of the Constitution, its origins, influence, and relation to democracy. That's an important subtitle. And this is from chapter 1 and excerpted for you on page 38. Magna Carta, also called the Great Charter. But I want to start with this quote from Smith where he says, "Constitutional government is not necessarily democratic. Usually it is a compromise in which monarchical and aristocratic features are retained." At the bottom of that page, he talks about what the Great Charter actually meant to the mass of people in England at the time. It refers to William the Conqueror, King John, the feudal barons. Those last three lines on page 38. "The Great Charter extorted from the king on this occasion, though frequently referred to as the foundation of English liberty, was in reality a matter of but little importance to the common people." And so we're subjected in what education we get, if you're like me, to these ritual exhortations of its greatness and how they echo forward to 1787 and 1789 and today. And people put their faith in the Constitution to stop Trump, and all of that is where we were conditioned to believe this. And what Smith is writing about is what the Magna Carta actually meant to the mass of people. On the top of page 39, he continues, "The important provisions of the Great Charter relate exclusively to the rights of the church, the nobility, and the freemen. The serfs, while not included within the benefit of its provisions, were an overwhelming majority. About 4/5 of the adult male population were below the rank of freemen." The Great Charter was, it is true, an important step in the direction of constitutional government, but it contained no element of democracy. And so you have in the evolution of the Magna Carta, in Smith's words, you have the monarchy having this check put on it, and so it moves from monarchy to aristocracy and oligarchy. And yet what we're conditioned to believe, like Tom described as constitutional DNA, is that it's this radical democratic document where people's rights are protected. At the bottom of page 39, in that the full paragraph under limited and irresponsible government, Smith says the monopoly of political power enjoyed by the king was broken down in England when the nobility compelled the signing of Magna Carta. This change in the English Constitution involved the placing of a check upon the king in the interest of the aristocracy. So it's not a check on the haves by the have-nots, it's that haves in the Magna Carta put a check on the have-mores. And then he goes on to say later, with the development of the House of Commons as a separate institution, the power of the king was still further limited, this time in the interest of what we may call the commercial and industrial aristocracy. This system of checks and balances must not be confused with democracy, Smith says. It is opposed to and cannot be reconciled with the theory of popular government. And then over on page 40, he talks a little bit about the House of Commons and how the name itself is a piece of mythology. It was not, however, a popular body in the 18th century. In theory, of course, as a part of Parliament, it represented the whole English people, but this was a mere political fiction, since by reason of the narrowly limited suffrage, a large part of the English people had no voice in parliamentary elections. Probably not 1/5 of the adult male population was entitled to vote for members of Parliament. So we have the carryover from this, here's the people who are people, white English men with property, they get to vote. Only 1/5 of those actually get to vote, not even counting women and all the other classes of people who don't even get counted as part of government. And I'll finish up with what Smith says in that last paragraph. While the interests of the landholding aristocracy were carefully guarded, the well-being of the laboring population received scant consideration. I'm guessing you find similarities between then and now. The Poor Laws, the Enclosure Acts, and the Corn Laws, which had in view the prosperity of the landlord, and the laws against combination, which sought to advance the interests of the capitalist at the expense of the labor, show the spirit of the English government. But it is not in statute alone that this tendency is seen. English common law shows the same bias in favor of the classes which then controlled the state. And let me repeat back on page 38 what Smith starts with. Constitutional government is not necessarily democratic. And as Tom said, those guys who wrote the Constitution were bathed in English common law, and what Smith says is English common law shows the same bias in favor of the classes which then control the state. So we can see where it comes from. To dig deeper into the nasty history which got us to where we are, it was not just English common law, but the spirit of colonization, sort of spearheaded by the church. How long do you want to take a break? 5 minutes?
Yeah, we can.
Okay.
Just a quick break.
We'll leave it up to you. Do you want to take a quick break, 5 or so minutes, or keep going so we finish early, or finish close to on time? What do you all want to do?
5-minute break? Okay.
Okay.
So try to be
All right.
back here at 8:25.